case on? Right, this is A in the London Borough of Enfield. Yes, Mr. Paget.
My lord, can I apologise for attending the court late?
Well, you were notified, and it's on the cause list as a 10 o'clock start.
It is.
And we have to finish by 3:45.
Yes, I apologise for the error in not coming, thinking it was 10:30. We didn't get the listing through. We obviously didn't think this case was important for some reason. But I'm very confident that the oral submissions will be finished by lunchtime in any event.
Both sides?
I think so, yes.
Right, okay. And I think we would like to hear from both of you on the two substantive points before we get on to the question of what relief is appropriate.
Yes. Yes, I'll deal with ground 1 and 2 first, and then are you suggesting that you'd like to hear from the respondents on those two grounds before then making submissions on ground 3?
Right. Just to remind everybody that the applicant or the respondent is subject to an anonymity order.
Yes.
Right. Well, you can take it, Mr. Paget, that we have read the review decision, which is the primary focus of this appeal. We've also read the judge's judgment, and we have read the skeleton arguments.
Well, we're obliged for that indication. There's a core bundle. There's a very small supplemental bundle that should run to 39 pages.
That's the second review decision.
Yes.
And what's this possession order? What's happened there?
That's the landlord obtained a possession order, but that hasn't been enforced, and we've extended the lease.
Right.
The second review papers will become relevant on one element in relation to whether this appeal is academic. And in addition to that, my lord, can I just also check that the authorities bundles now includes the additional recent cases of the court considering where there's no explicit sanction for non-compliance?
Yes, we've got those.
Look, in this case, the judge below made 3 primary errors. He found that the reviewing officer needed to consider the full ambit of section 208 when the applicant is expressly requested out of district accommodation. That's ground 1. He then made a secondary error in concluding that even if, as the judge found, that the reviewing officer was bound by section 208, the judge was wrong to find that the reviewing officer needed to search in the 1.6 miles between the property and the appellant's boundary in review. This error is judicialisation, which was so disapproved of in Moog and Ealing, paragraph 145.
That goes back a lot further. It goes back to Lady Hale in some previous case about judicialisation of claims to welfare services.
Yes. So the first error was judicialisation.
Yeah.
The second ground of appeal relates to section 2084.
Yeah.
Whether that is relevant to section 202 reviews and any section 204 appeal. It isn't. And the judge's finding that it is was judicial blindness. The third ground of appeal relates to the remedy. That he found below that he could not use the highly likely test set out.
No, I follow, but we're going to park remedy for the time being.
But I'll just characterise what I say that error is to follow the theme of judicial missteps. That's a judicial overreach.
Right.
So turning then to ground 1. This was a situation where the respondent applicant didn't want to live in the
Yeah, I
district
understand
because of
She wanted to be in Hillingdon or Broxbourne.
Yes. So she's explicitly said, I don't want you to follow the usual ambit of section 208. But she didn't say, when specifying those boroughs, that I want to be as close as possible to Enfield. And indeed, the full and main thrust of her review request was, look, I don't think this property is suitable for me because there's proximity to my ex-partner's associate. So it would be on the facts, putting aside the law element of section 204, and the fact that it hadn't been 208 and it hadn't been triggered, the odd that there was a requirement to look nearer if she was saying, as part of the review, look, actually this doesn't work for me, this particular part.
So you say that looking closer would have put her back in the danger zone?
She was complaining about being in the danger zone of the property. Now it might be one of the particular side streets was less proximate, not in the sense of location, but in the sense of ability to find. But it wouldn't have made any difference to the issues that she was concerned about, which is, on her case, look, if I'm on this particular bus route, it's likely that I'm going to get in contact with people. And if she happens to be a couple of streets nearer the boundary, well, it's highly likely if she's going to visit family members, she's going to be using the same routes. Yeah. Her principal complaint was, I want to be moved to the other side of your local authority district, up in a different area, which makes it easier to reach my family members.
Sorry, I thought she wanted to be moved to Hillingdon or Broxbourne.
She did. And the rationale for that was, well, from there, it's easier for me to access. I'm not going to be going along these particular bus routes. Whereas if she was just a little bit nearer, it's highly likely she'd have to use the same bus routes.
If we're going to get into this sort of detail, wouldn't it be helpful actually to have a map?
Yes, we can provide that.
I mean, I don't know whether it's necessary to get into this
I
sort
don't
of
think
minute
it is.
detail, but if you are going to go there, I for one, not being intimately familiar with the layout of every London borough, it would be quite helpful to have some sort of map. But I'm not sure it's necessary, but if you are going to go there.
I wasn't going to go there beyond this point that the review submissions that the reviewing officer was considering didn't bite at all.
Well, we haven't seen the review. We haven't seen the review submissions. We haven't seen the minded to letter. We've just got the review decision.
Correct, my lord. Yes.
Yeah.
And you can tell from that the review officer deals with this in paragraph 47 through to 50.
Yeah.
And that granular detail is at paragraph 48 about the bus routes. In Zolonazel, the Supreme Court gave guidance as to how section 208 should be utilised, and this court is very familiar with the follow-through of that decision in creating placement policies, complying with placement policies and looking at metropolitan hubs rather than precise distances as crow flies. But importantly for this case, my lord, the case of Zolonezu is at page 349 of the authority examples. And the parties in this case have marked up the relevant sections of paragraphs that they want to rely on, and paragraph 19 at page 359 is germane here, because that is more familiar to this court because it says, look, if you create your own policy and you comply with that, you don't have to immediately place everyone who's asking for housing in your district if you want to keep some aside for certain individuals, etc. But it's also relevant for this case because, unlike those other cases, my lord, this is a case where the applicant is saying, I don't want to live. And that is dealt with on page 360, please, my lord.
360?
360, yes.
Yeah.
So it's the second
Yes.
part of the paragraph.
Yeah, between A and B.
Exactly.
Yeah.
There will be some cases where this does not apply. This is such a case. For example, where there are benefits, and there were in this case.
And what do you say Lady Hell meant by this will not apply?
Well, she references it in the.
I mean, what she has done,
Yes.
as I understand it, is she's looked at section 208 itself,
Yes.
and that's only about in borough as opposed to out of borough placements. Then she's looked at the supplementary guidance, which she quotes at paragraph 18, and she brings all that together in paragraph 19, which is partly section 208 and partly the supplementary guidance. And it's only in the supplementary guidance that you find this as close as possible phrase. And then she says in paragraph 19, there will be some cases where this does not apply. Is she referring now to section 208 or to 208 and the supplementary guidance?
I think she's probably just referring to section 208 because that's the explicit bit that is quoted in the first part of paragraph 19. The reasonable practicability.
Yes, but she goes on to say if it's not reasonably practicable to accommodate in borough,
yes,
they must generally and where possible and so forth, and that's simply reciting the supplementary guidance.
Yes, that's true.
I mean, it looks more like this. The thing that is closest to the word "this" is the words that come from the supplementary guidance.
Yes, we're using close in a different sense there. Yes, but that's right. That follows logically. She's looking at the statute, then looking at, well, what does how's the guidance interpreted this? And then said, oh, actually, that can be disapplied. But that is the correct reading of yours, yes.
Right.
We'll just look quickly at the code itself, which is that was relevant at the time. Is at page 157.
The wording hasn't changed, though.
I don't think it, no, it
The
hasn't.
paragraph numbers have changed a bit, but the relevant wording is the same, both in the code that was applicable at the time and the updated version.
Yes.
And I think you tell us, or the front sheet tells us, that the code we've got, it says May to October 2023. I noticed that the review decision refers to a 2006 code which I haven't looked at. I don't know if it's any different from what there is now.
I don't know.
But nobody seems to say that it is. I'd
No.
assume that the substance of the code is the same.
The code at the time.
If you look at page 89,
Thank you, my lord.
what the reviewing officer says is she's considered relevant information, including Homelessness Code for Guidance or Guidance for Local Authorities 2006.
I think that might be an error on her.
It's the sort of problem that I think we encountered in Moog. That people just, for some reason, local authorities just don't seem to keep up to date with all their template forms
Yes.
or whatever they do. Seem to have just don't keep up to date with the relevant provisions.
Well, I think that's true as a general comment. I think that would be very surprising if the template hadn't been updated in some 17 years. I think it's more likely to be a typographical error. I'm just seeing it's explicitly referenced section 17.6.
What?
I'm just seeing she explicitly references section 17.6, but I can't see that. Paragraph 17.6 is at page 187 of the relevant guidance.
Yeah.
Account has to be given to the social considerations relating to the applicant and their household that might accept
Sorry, where are you reading from, Mr. Paget?
from
17.6, yes.
Yes.
Yeah. Yeah.
Including any risk of violence, harassment at a particular locality. So that's to be taken into account when saying, okay, well, we're going to consider your request, we're going to consider the guidance, and we're not going to place it in bar. Respondent to this appeal in their skeleton argument suggests that Solomezu has in some way created a common law extension to section 208. We would submit it hasn't. All it did, especially in that paragraph we were just looking at, is just applied it, sought to analyse it, understand it, and apply it in the context of the statutory code as well. In Moog, there was reference to the development in subsequent cases as to how that's applied, but that doesn't mean that there is some additional criteria of some requirement to follow concentric rings added to section 208. So,
But you have a certain hierarchy, don't you? You've got section 208, that's the statutory obligation. You've then got Article 2, the 2010 order, which talks about distance between the accommodation and the district. And then you've got a guidance to which the local authority has to, quote, have regard, unquote, which is not mandatory, you must have regard to it. And it's the guidance which talks about being as close as possible to the applicant's previous address, not the district, but the previous address. So you've got these three different elements.
correct. In the normal type of case. And then when you've got an explicit request like this, then you need to modify those slightly in light of the other elements of the guidance, specifically section 17.6 took you to. So our principal submission in relation to ground one is that this is not a case where you needed to go through all that because of the specific requirements of the applicant. So in deciding that we were wrong to do that, the court below was wrong.
Yeah, right, got that.
Secondary argument in relation to ground one is that even if somehow we were obliged to go through the usual process in relation to a review as to suitability. So let's say, despite what the applicant said, we have to follow the usual process that you just mentioned.
I look for somewhere that's closer to what?
Well, no. What we have to do is go through those three bits,
Yeah.
and then I would suggest also look at the case law that helps you in applying those three bits. And what that case law says is, no, you don't have to go either. You don't have to go and look in the estate agent's windows in Harringay and see if there's anything at all around. And in this case, what you don't have to do is walk the streets between the property and the boundary to see if there's anything vacant that you could try and utilise. Because that falls foul of how the appellant court has said you've got to approach this, which is use your own policy and comply with that. And it's surprising that that guidance in Moog wasn't drawn to the judge's attention below, because Moog says, in rounding up all those other comments that the other appeal judges have said along the way since Zolometi, is that there's no common law extension to section 208. You don't have to look in all the streets in between Milton Keynes and London. You can look at hubs, metropolitan hubs, and you don't have to go and look as close as possible. And in particular, where you've got a policy like ours, which is in the bundle at page 108, please, on yours.
Which bundle are you in?
The core bundle.
Core bundle.
Yeah.
So this is our response to considering that hierarchy that you just mentioned. Section 208. The statutory instrument of 2012, and then the guidance which you say is non-statutory. And you mentioned, my lord, that it's only in the last bit of that we have this phrase, as close as possible. If we look at the policy, which was developed as a response to that and a response to the appeal court saying, develop a policy and utilise it, and then what you'd be doing is lawful. It is at page 111, under the subheading 4.4 location.
Yes.
So in that part, it says we'll try and house in borough. However, just like it was said in paragraph 19, there are situations where we won't. And bullet point 1, full square, and that's the primary submission in ground 1. Yeah, we're in that. But even on this secondary attack on ground 1, the remainder of the section says this: where we are offering accommodation outside Enfield, we will support households in finding accommodation out of the borough. Where possible, this will be close to Enfield, taking account of full of the other factors as set out in this policy. The property is close to it complies with that part of their policy. That part is freestanding from the bullet point above. It is said by the respondents, look, that is a contextual measure. It is, of course it is. And so I think in some way they're saying, well, so therefore the judge is entitled to say that in this instance, by not considering anything in between, you haven't complied with the policy. But that is a classic evaluative judgment that would only be challengeable in a Section 204 and in this court on Wednesbury principles. That has been hied off for the reviewing officer to consider. Look at the policy, what's the policy say? Apply the policy. If they haven't applied the policy because someone thinks that this is definitely not close, which is an evaluative judgment, well, you can appeal that on rationality grounds. In finding that there was an error of law under the secondary element of ground one, the judge has taken another judicialisation step, which is exactly what the court above says not to do. Just leave that to the reviewing officer of the policy. Those are my submissions in relation to ground one.
Very economical, Mr. Paget, thank you.
Can I now turn to ground two?
Yes. This is the duty to notify.
Yes.
Yeah.
And this court has recently been again guiding lawyers as to what happens when a statute doesn't require something to be done in mandatory terms, but doesn't explicitly.
There's no doubt that Enfield failed to comply with the imperative duty to notify within 14 days.
Correct.
That's a given.
That is a given. And it's a very unusual, just looking at that particular provision in isolation, it's very unusual because you can never cure that. If you don't, if you've subsequently notified, which is what happened in this case, that doesn't cure the breach.
No, I follow. If you're required to do something by statute in 14 days and you do it after 21 days, you haven't complied.
Correct.
But what's the purpose of the notification?
Well, the courts have considered that in other cases. And it is because, and this feeds into the oral submissions that I'm going to make, the court has already understood that point. And I want to make a secondary submission, which is, even if there was an ability to challenge that failure, it's not by the route of Section 202 and Section 204. So I'm making submissions on the ambit of Section 202. But the court just asked, well, what's the point of the Section 208 notification? So you will have a suite, you often have a suite of obligations that are owed to a particular individual. And some of them are location specific. And so consequently there is relevance.
Is the obligation to notify owed to the individual? I mean, that rather depends on what the purpose of it is.
No. Is the obligation on Section 208 owed to that individual?
Well, they're not entitled to be notified.
So they don't know.
Yeah, that's what I'm saying. You,
No.
you said you were talking about sorry, you started talking about obligations being owed to an individual. I'm just
Yes.
sort of,
And sorry, I should have made that clear. Obligations generally, not under Section 208. Obligations, and for example, it might be that the person has continuing obligations under Section 117 of the Mental Health Act 1983. They may have Care Act requirements that are all outwith of the obligations under the housing legislation, and are also, as I will go on to submit, outwith any ability to review under Section 202.
okay, sorry, this may just be me, but I'm struggling to follow where you're going with this. I thought I'd asked a relatively straightforward question. What is the statutory purpose behind requiring one local authority to notify the other?
Yes. it was a simple question, and I understood it, and I'm trying to answer it by saying that there's no commentary in the Housing Act 1996 itself, or really in any practitioner textbook or analysis, either before or after the recent Kadir case.
Well, I think Mr. Van Heegen's referred us in his skeleton argument that we haven't got in a bundle to SACUPEMA, which suggests that it's there to protect the host authority. Its purpose is to stop the placing authority from simply decanting people into another authority's district. So it may be that it's there to allow the host authority to object or to possibly seek judicial review.
It wouldn't go as far as that, the second part. That may well be a good reason, because it doesn't go to the second part, because there's specific obligations if you're going to refer to another local authority under the Housing Act legislation for those housing duties. So it arises in this way, my lord. You've got housing duties to someone. Now, you've found them to be owed the main housing duty. That means that they're vulnerable. They may be vulnerable in a number of different ways. Now, that type of person quite often has other duties owed to them outside of Housing Act legislation. And I just gave you some examples of that under the Care Act, could be Children Act, could be Mental Health Act. So I think the statutory purpose is to let the new authority know we are complying with our duties under the Housing Act. We're placing in your borough because we can't in our own borough. We're going to take that part on because we're not doing a referral under the Housing Act legislation. But just letting you know, this person lives in your district, so you're aware. It could be.
So absent a referral, the placing authority retains Housing Act responsibility, if I put it broadly.
Yes.
And it is just, therefore you say it can only be, as it were, to notify the other borough, we place somebody in your borough, don't worry about it for Housing Act purposes, but you just might like to know they're there.
Yes, exactly.
I mean, does anybody know whether the host boroughs receiving these notices file them somewhere, refer to them somewhere, screw them up and throw them in the bin? You know, what do they do?
Yeah, it's unknown what they do. They certainly don't. They don't take any.
Hang on, I mean, you say it's unknown. I mean, what is your borough?
I don't know what our borough does in relation to Section 8 notifications to us.
Somebody must know in this system. Or is everybody just mystified by it?
One of the difficulties is it doesn't expressly say within Section 208. This goes to your question: why are you notified? And I've given you some answers as to why you might.
I mean, I know in a sense. It supports your argument to say, well, nobody actually knows what purpose of any of this is. So, you know, why on earth should it have this sort of consequences that the respondent says?
Yes.
But I'm just sort of pushing to try and, since you're first on your feet, to try and understand what the general consensus is, if any, as to what these notices are supposed to achieve.
It's a very sparse notification.
Yes.
The particulars required by Section 208(3) don't, for instance, say this applicant is going to be in need of psychiatric help, or this applicant needs to be close to a particular school, or
no,
anything like that.
No, it doesn't require any particulars at all. And so that goes. So one of the reasons I think why it's unknown what happens is because you don't have to do it. The receiving borough has to do absolutely nothing with it. There's nothing in the Code of Guidance because it's outside of the Code of Guidance. It's nothing to do with the individual's responsibilities under the Care Act, under the Housing Act.
It probably suits your purposes to be mystified. The purposes of the argument. Sorry, I'm being a bit blunt.
It certainly is far removed from the explicit duties that can be challenged under section 202.
What follows from
And so
that?
I probably am wrong, my lords. I apologise when I was positing about purpose, because if you just look at the section and the local authorities that has to be notified, it's at page 113, please,
Yeah.
my lord, in the authorities bundle. And what it requires you to do under subsection 2 is notify the local housing authority. A local housing authority has obligations under the Housing Act 1996. A social services authority has those other obligations. Often they're unitary in London authorities, but they won't be very often outside of London. So if the statutory purpose is to let the receiving borough, the district, know, it's even more opaque. It's one removed, because you're not actually notifying the relevant authority about those suite of other obligations that might be owed to someone.
I mean, might it be something to do with notifying the host authority that there's some accommodation which is no longer available to them to house people in the host authority? Yeah, I mean,
that would be relevant to their obligations, yeah.
But none of that. If that were the case, I mean, that's, as it were, for the benefit of the host authority to know. Sorry, one of the potentially available pieces of accommodation in your host local authority area is no longer available to you to house people you may have housing duties to. But it doesn't really affect. It's not for the benefit of the person who's being housed.
No, not at all.
That was my lord's point. The person who's being housed is not the person who's given this notice.
Correct. I know that person continues to be held under obligations that continue from the original authority.
You said a moment ago that a failure to notify is not a ground of challenge under section 202.
Yes.
Does that mean that you're saying that the county court didn't have jurisdiction to consider the point?
Yes. So I'm not going to make any submissions on the effect of this breach, but can I get all submissions which won't augment those recent cases? But look at section 202.
Yeah.
And the ambit of section 202. At page 96, please. It gives a specific list of rights and obligations that can be challenged by way of section 202. It specifies them in subsection 1 to include what duty is owed to him, the applicant, under specific section.
Yeah.
Section 208 for notification duty. It is not a duty, as we were just discussing, that's owed to that person. And consequently, it's not within the specific elements that can be challenged by way of section 202. It's a decision that is actually, it is a step that is out with of any section 184 decision or any suitability element. It's completely separate. In James and Hartsmere,
Well, that's what I was going to ask you about.
In James and Hartsmere, they look at what has happened when this part of the administrative court was hived off into the county court. And there's 2 points to make. One, it wasn't universal for some reason, perhaps by admission, deliberately. There are still, as this court knows, certain parts of that housing process that remain under the jurisdiction of the administrative court. An example being when you're first provided interim temporary accommodation in section 188, and then consequently you get those
Personal housing plans is another one. Seems to-
Yes, you know, if you get that wrong, what is the effect on later steps? And obviously the court is.
So for Jones and Hartsmere, what was challenged, I think, was the contracting out
Yes.
of the review function
Yes.
by the local authority to an organisation which conducted reviews.
Yes.
Now that's not specifically mentioned in section 202 as a permissible grounded challenge, but the Court of Appeal in James said it was.
Yes. So there's 2
Despite
points.
my grumblings about it in Pagnotti.
There's 2 points to make about that. One is general, one specific about what they were looking at there. The general point is that they say, consistently with Begum back in 2000, is that when it's been hived across, you use the same parameters as judicial review principles, so illegality, etc., procedural fairness, etc. That doesn't increase the ambit of what you're allowed to challenge. That just shows how you're allowed to challenge illegality, etc. You use the judicial review principles when undertaking section 202 and section
Look, it must be a necessary part of this argument that James and Hartsmere is wrong.
I don't think so, because for the second bit, what James and Hartsmere is challenging is the lawfulness of the review decision in a particular type of way. They say, well, you haven't complied with the contraction out, so the decision maker doesn't have standing, so it's an unlawful decision. That's very much directed at looking at, did the local authority properly conduct the section 202 review? Was that a lawful decision? So it's looking at the mechanics of the section 202. It isn't looking at what additional categories can be advanced. And that would go contrary to the settled position, which is that, for example, section 188 challenges are still in the administrative court. If James and Hartsmere just open the doors in a general sense like that, then those cases should be now pursued by 202 and 204, and they're not. So it is wrong for the respondent law to think that James in any way has enabled this type of challenge to be advanced at section 202.
If you look at what Lord Justice Peter Jackson said at paragraph 31 of Jackson Hartsmere, which I think is which is, in my view, the correct interpretation of section 204 is that the point of law arises from a decision if it concerns or relates to the lawfulness of the decision. On one view, the sending of a notice is no part of the decision at all. It's just an administrative act that should be done following the decision.
That's correct in two senses, please, my lord. The first sense, it doesn't relate to the 202. It's an earlier step that has taken place at the time of the 184 decision. And when the court was looking at the ambit of section 202, it's saying, well, look, you can't take an unlawful decision if you don't have standing. But section 2A is absolutely nothing to do with that. That is ancient history when you come along to M202. So there are a number of considerable hurdles as to being able to use this route to challenge it even if you were entitled to a remedy, which you're not for the reasons that the court knows in relation to the first part of this submission. This has not been considered with proper argument. It was a decision that did not need to be made because of the facts in applicability. The comments made in relation to this and now that the court has looked more carefully at section 202, the court previously in that case did observe that there's no explicit entitlement under 202, but you can't then shoehorn in certain things. In fact, the only thing that has been shoehorned into section 202 that's not part of the explicit list is, well, you, the decision maker, don't have standard time, in other words, the contracting out point. Everything else has remained outside section 202, including things that are much more relevant to the applicant about what duties are owed to them. Are they entitled to interim temporary accommodation? Those are my submissions in relation to round 2.
Right.
And the court has any questions. I think the court was proposing then to
we'll hear from
the
Mr.
other side in
Van
relation to those.
So, my lords, I'm going to deal with grounds 1 and 2, and if we get on to it, my learned friend Miss Smith's going to deal with ground 3. Can I make 3 preliminary observations before I deal with grounds 1 and 2? One, just in response to a comment my lord made. Our skeleton is at the very back of the core bundle.
Yes.
We've got copies of the perfected.
You've got a perfected one.
Yeah.
Either yesterday or the day before.
Yeah. And then 2 more substantive comments. The second preliminary point I want to make is this appeal is entirely academic in the sense that the appellants themselves have obviously withdrawn this review decision, and they've gone on to make a further review decision, which is what appears in the supplementary bundle.
So that's been decided against you, hasn't it, by Lord Justice Newey?
Yes, I'm not seeking to go behind that. So obviously there's an extant appeal in relation to the new review decision, and that's due to be heard next February. The point is that this court is therefore not going to grant any relief because there's no review decision in respect of which this court can grant relief. And anything this court's going to say is going to be obiter because there's no issue between the parties over that review decision because it doesn't exist anymore. So although Lord Justice Newey has decided that nevertheless this appeal is going to go ahead, I think it's important just to bear that in mind by way of background, especially in relation to ground 3 when one's talking about relief, because there is no relief. And then
you say the decision will be overturned. It won't be overturned in relation to the issue for which permission was granted and which has been argued. We have to decide that issue. And in fact, you might not get any relief at the end of it at all. Like, doesn't make our decision completely pointless. That's Lord Justice Newey's point, isn't it?
yes. I mean, in a sense, if the underlying decision's gone and this court isn't going to grant any substantive relief, then in a sense it is all a sort of theoretical discussion because there's nothing to sort of grapple with, and so in my submission, any decision would be obiter. And in particular in relation to ground 3, where the judge below said, well, if it isn't an inevitability test, I still find that at that time,
Ground 3, which
yeah,
we're
yeah.
for the time being.
So you're saying that if we were against you on ground 1 in favour of the appellant and we give a decision to that effect, next week if the same point arose, you'd be standing up to say, well, it was all over, so let's have another go.
Well, this is the Court of Appeal, and what the Court of Appeal says is taken very seriously below. And
You're saying that technically you'd be saying to the judge below, look, it was all over to you, not bound by it.
well, it would be, and we've seen that problem. If my own friend takes the court to Guist, the relief point was over to there as well. It's not the best case in order to set out principles in relation to grounds 1 and 2. But
I'm not sure I buy that.
very well.
I mean, there is a practice which the court applies in deciding whether or not to hear appeals which are said to be academic.
Yes.
And sometimes it says no, and sometimes it says yes.
Yeah.
If it says yes, that it will hear an appeal even if it's academic, then at the moment I understand why the court's decision on that appeal should be characterised as obiter.
Because it's not resolving any issue, the court's not granting any relief.
In which case, the whole practice that the court has evolved for dealing with such cases is a waste of time.
No, I mean,
Well,
with respect, you rolled 2 points into that last response to my lord. You said it's not resolving any issue, it's not granting any relief. There's two separate things. There is an issue
Yes.
to be resolved,
Yes.
and our reasoning on the resolution of the decision of the issue, which we have to decide is necessary for the determination of the issue.
Yes.
The fact that we may not grant any relief at the end of it is a different point, isn't it?
Yes. No, I accept that. And the last point, sorry.
Sorry, on that point, I apologise to the court. I didn't make the points on the effect of this second appeal. That's in the supplemental bundle, and the grounds of appeal in the second appeal
Are similar.
are exactly the same. They're running exactly the same point about section 208, no concentric rings, and exactly the same point about failure to notify.
Yeah, well, I think
So
that's why
that-
Lord Justice Newry decided this appeal should go ahead.
Yes, that appeal was then listed in the county court. The second appeal was listed in the county court, and that was adjourned off because it was recognised that this court will give guidance to determine that,
right.
Which could easily settle it.
The last preliminary point I want to make is in relation to the 3 cases which my lord's drawn our attention to. My only friend didn't refer to any of those 3 cases, but obviously he hasn't in writing formulated any argument in relation to those cases. He didn't say anything about them orally this morning, and so we don't really understand what his case is in relation to those authorities, if anything.
Well, can I insist? I got the ratios in all those cases to apply to this situation.
So, I mean, I was going to say this is rather inadequate procedurally, and I think I'm fortified in that submission now, where I'm interrupted in my submissions to say where he adopts the ratios. I just want to lay down a marker that if this court is going to rely on anything said in those cases, in the absence of anything in writing or developed orally, we may need time to respond to it, because, as I say, it doesn't form part of the appellant's grounds of appeal or his skeleton argument, even his perfected skeleton argument. So I just lay down that marker. So if I could turn to the grounds, dealing with the first ground, I want to just try and look firstly at what is the first ground. And so if I could just take the court to the core bundle and the amended grounds, and it is page 13 of the core bundle.
Yeah.
And it's paragraph 2. And what my learned friend says in his amended ground 1 is that the learned judge was wrong to conclude that a failure on review to search for accommodation that was as close as possible as the previous accommodation was a breach. So what he's saying, and this is really his ground 1, is that he accepts that there was a failure to search for accommodation, but he says that failure to search for accommodation is not sufficient to give rise to a breach of section 208. And if we turn to the judgment, which is also in the core bundle, the relevant bit really starts at page 57, paragraph 38. And there's a heading, decisions to ground 1, and it starts at paragraph 38. the judge says it's common ground the respondent, who obviously now the appellants, didn't try either at the time of its offer or at the time of the review to carry out any search to secure accommodation. So the situation, as accepted by the appellants below, is that they never searched for accommodation. And it's on reliance upon that concession, we get to paragraph 39. I find that in failing to search for accommodation as close as possible, the respondent's in breach of section 208. And then at paragraph 40, the judge rejects Mr. Paget's submission, which he's repeated today.
Which bit of section 208 is the respondent in breach of?
Can I come to that when I develop my submissions on ground one? Because it's section 208 as developed in the cases, so we need to look at the cases.
That's what I think you were going to have to
I am going to do.
unpick all that.
Yes,
because
exactly.
There's a whole mix of stuff there.
Exactly.
There's section 208, there's article 2, and then there's the
the
code
code.
of guidance.
Exactly.
And you can't just put them all in one pot and stir it around as if it's a stew.
Exactly.
They're separate ingredients.
Exactly. And there's what the Court of Appeal has said about those three things, which we need to look at. So going back to this, so paragraph 40, he rejects the submission that simply asking for outside Enfield somehow disapplies the duty to search. And so ground one below, and as formulated today, is simply the argument we didn't search, and the fact that we didn't search doesn't mean that we're in breach of section 208. And our response to that is, no, section 208 applies. It applies in all cases, or whatever. We'll come on to exactly what I mean by section 208 applies. And there is a duty to search. And by not doing anything at all, by not carrying out any searches at all, that is a breach of section 208, or as it's been interpreted by the courts.
When you sort of just, maybe it's just your advocate's shorthand for not carrying out any search. I mean, it's a search to secure accommodation as close as possible to where the appellant was previously living in the London Borough of Enfield, is what was actually said on both occasions, in 38 and 39.
Yes.
I mean, so if we expand out fully the judgment, is your submission, does it still stand? In other words, you say they had to search to secure accommodation as close as possible to where the appellant was previously living in the London Borough of Enfield. That's what you say they should have.
They should have carried out a search, yes.
So to find an accommodation as close as possible to where the appellant was previously living in the London Borough of Enfield.
What I'm going to say is, I'm going to say yes to that, but what actually I'm going to say is a bit more nuanced, and actually their obligation is to search for accommodation as close to their borough. Because it doesn't really work if you say previously living, because you could put someone in Stoke-on-Trent and then you could then search again and say, well, this is as close as to Stoke-on-Trent as where they were.
How did it fit with your client's personal circumstances at the time to say that what actually the duty that was owed to her was to secure accommodation as close as possible to where she was previously living? That's precisely where she didn't want to be.
Yeah, I mean, it's as close to where she was previously living, but not in Enfield. As close to Enfield as possible, because she had her mother there, she had a support network, she needed to be close, but not in her danger area, which was Enfield. And I want to make this point as well in relation to section 208, is all out of area placements are subject to the same law. There are two ways in which you get placed out of area. Either, and this is the most common scenario, the local authority decide that you don't have a reason to stay in borough, you're not prioritised for borough, so they're going to send you outside. And the second way in which you go outside is you, the applicant, say, for one reason or another, I don't want to be in your area. And those are the two ways in which applicants...
Can we just unpack the first one? Then?
Yes.
It's not a question of the local authority saying you're not prioritised for being in borough. I mean, in a sense, it's all to do with the shortage of housing stock, isn't it?
Yes, which is what...
Given an infinite housing stock, they would be able to put everyone in borough.
Oh, absolutely.
It's just, given the priorities to which your personal circumstances give rise, we don't have sufficient housing stock in borough. We have to look further afield.
Yeah. Absolutely. And my own friend's already taken the court to their policy, which reflects a series of priorities. There's nothing magical about this case in the sense that, yes, it was the applicant who said that she didn't want to be in borough, but that in a sense is a red herring because all out of area cases should be treated in the same way.
It seems to me, if I may say so, to be remarkably odd that the applicant says, I'm coming from Enfield, which is North London, North Central London, verging towards the east. Where I want to be is in Hillingdon, which is the westernmost London borough. And then she's offered accommodation, which is in the neighbouring borough to Enfield, much closer than where she asked to be put. And she says, oh, that's too far away. I mean, that's really bizarre, isn't it?
Well, no, it's not bizarre on the facts of her case because she's put in a borough which is south or below Enfield, and then in order to get into Enfield, she has to use this bus route,
Yeah, which the reviewing officer looked at in great detail.
Yeah, which is problematic for her. But the points I wanted to make in relation to this ground is that, in a sense, we don't get onto that because the ground is a very narrow one, which is, well, we didn't have to search at all. And so if my own friend's wrong about that, and there is in fact a duty to search.
Search for, this is where I picked you up before, you
Yeah.
keep truncating it to not search. I mean, I want to pin you down to the actual duty you say that they had. What was the search? And my lord has just put to you, I think if I'm looking at the correct map, I've got it in front of me. Where your client asked to be put where? She preferred to be put where?
Hillingdon or Broxbourne.
Now, Hillingdon is a long way away from Enfield.
Yep.
Compared to Cranfield.
Yep.
Which is in fact a neighbouring.
Yep.
Local authority. So when she made her request to be put into Hillingdon, how does the duty to search for a property as close as possible to where she was previously living in Enfield?
I'm going to demonstrate that by reference to the cases. But the factual background in this...
Forget the cases just for a second. Can you actually just sort of, just as a matter of common sense, try and understand what she was actually A, asking for, and B, now complaining about? She didn't want to be in or proximate to Enfield. She was happy to be in London, which is a long way away for the personal reason.
Which she wasn't saying she didn't want to be close to Enfield. She had to be close to Enfield because her mother was there.
Well, how does Hillingdon help her?
Well, because she said she wanted to be in Hillingdon, she wanted to be in Broxbourne, but that doesn't mean she didn't want to be close to Enfield.
Well, Hillingdon is not Brent. What about, what's wrong with Barnet? What's wrong with Harrow? What's wrong with Brent? What's wrong with Ealing? What's wrong with Camden? What's wrong with Islington? What's in fact wrong with Harrogate? All Waltham Forest or Redbridge, all of which are closer than Hillingdon.
Well, what this appeal is about is, can a local authority not search at all and still comply with Section 208? And I hope to convince the courts that the authority can't do nothing and comply with Section 208 by looking at the relevant
I
case.
suppose they had placed her in Hillingdon. She said, I want to go to Hillingdon. And the local authority said, all right, we found you a place in Hillingdon, off you go. You still have to search for a place as close as possible to where she was living in Enfield?
I accept there may be circumstances in which she might waive her right to challenge the breach of the duty. But the duty applies. The duty is not disapplied in certain cases. And I mean, we looked at Section 208. It's not disapplied in cases of domestic violence. It's not disapplied in cases where the...
You're straying out of 208. 208 is a duty, where practicable, to house somebody in borough. And it is agreed in this case by everybody, the applicant, the professionals involved in her case, that it was not practical to place her in borough because of the danger from NB and his associates. So, Section 208(1), on its plain vanilla meaning, has absolutely no application to this case because it just wasn't practical. It's been the duty has been fulfilled, if you like. It wasn't practical to place her in borough, so we're outside Section 208(1). So now we've got the guidance which is really what you're relying on.
Well, yeah. Can I take the court through the case law, because yeah. So there are really 4 cases on it which I want to draw the court's attention to. I want to go back to Nzelemesu very briefly, paragraph 19, and then I want to look at Abdikadir, Zaman and Moji, which in my submission really set out the law in relation to this. So if we could just go back to Nzelemesu to start off with and look at the question of what this applies to. My submission on that, this is page 359 of the authorities. It's paragraph 19. What, in my submission, Baroness Hell is saying here is that the due
Paragraph
19,
90. Yeah.
bottom of 359, going over to 360. What Baroness Hell is here referring to when she says this is the obligation to place in borough. She's not setting out some general principle that if the applicant has to be outside borough, because she gives examples of domestic violence or break links with negative influences, she's not then saying, oh, well, they can go anywhere. What she's saying is the obligation to place in borough is obviously disapplied in that scenario, because it would make a nonsense for an authority to have to place someone in borough where they've said they want to be out of borough. And if it's not clear from paragraph 19, in my submission, that becomes clear in the subsequent Court of Appeal authorities. So if we could start at Abdikadir. And I want to begin in Abdikadir at paragraph 37. So I'm looking at page 518. And in the middle of page 518, there's a heading out of borough placements. And at paragraph 36, my lord refers to Nzelemesu and the extract that we've just seen from Baroness Hale at paragraph 19. And then at paragraph 37, my lord says, the real problem in Nzelemesu is that Westminster had not explained how it came to its decision. And then my lord draws a number of general principles from the case law which have been analysed. And the most relevant for our purposes is Roman 3. Over the page at letter B, the housing authority has a positive obligation to show that in offering an out-of-borough placement, it's complied with its duty under section 2081.
Yeah.
And this is where we start to see the judicial interpretation of section 2081, because obviously, as my lord said, section 2081's got nothing to do with anything other than placing in borough. But there's a positive obligation to show that it's complied with the duty. And then if one turns over...
Do you accept that if somebody says, I do not want to be placed in borough, then the duty is the local authority has complied with its 208 duty? If it places somebody, it doesn't matter where they place them, in fact.
It
208, it's 208 duty.
Yeah, well, it obviously hasn't complied with 208 subsection 1, but the cases show that it doesn't have to, because obviously it would be a nonsense if it did, because the applicant said they want.
It has complied with 208, because 208 then he says place somebody in duties as far as practical.
Yeah, fine.
So it has complied because it's not practical, everybody agrees that, therefore 208 has complied with tick, end of story.
Yes.
Suppose somebody says, I'd like to move out of borough, but it is in fact practicable to place them in borough. What is the authority to do then?
Well, I suppose there's the practical issue. If the applicant asks to go outside borough and they're placed outside borough, it'd be very strange if they went in to
Suppose they're
complain.
placed in borough. Local authority says, we've got places for you in borough, we're not going to do an out of borough placement, even though you said you like to move to wherever, we're going to place you in borough. Can the applicant then complain?
Well, I don't really see how, because the authorities complied with the duty. Can I continue looking at Abdicadir?
Yes.
So we looked at paragraph 37. So yeah, that's about positive obligations. So then the judgment goes on to look at whether Ealing's complied with its positive obligation. So at paragraph 57, third line, my Lord says Ealing's response to the inquiry about what steps they'd taken to comply with section 208, subsection 1, did not mention any steps taken to investigate the availability of private sector accommodation. And then concluding there's no evidence that there'd been compliance with the policy.
Yes, but you have to look see what the policy was,
Yes.
which is quoted at the end of paragraph 50,
Yes.
page 522 of our bundle.
Yes.
Acquisition officer, the council's acquisition officers are instructed to focus on zone 1 and zone 2. Acquisition officers liaise with accommodation providers and check relevant websites on a daily basis for new supply.
Yeah.
What was alleged in Abdicadir was they hadn't done that.
Yeah.
And they'd been asked, as far as I recall, several times by your client solicitor, well, what have you done?
Yeah. No, I accept that. But what my Lord's doing here is setting out general proposition of law, which is positive obligation to show compliance, and then looking on the facts of this case, was there compliance? What's the evidence to see whether there was compliance? And concluding that there was insufficient evidence to show compliance. And then my Lord, at the end of paragraph 59, then deals with the sorts of evidence that the authority might want to adduce in order to comply with the evidential burden in order to prove that they've complied with the positive obligation.
And this is all to do with proving that you've, as a local authority, you've complied with your obligation as far as practical to put somebody in borough under 208. The case is all about somebody who's placed out of borough.
Yeah.
Out of the local authority.
Yeah.
And the case also was about, has the local authority proved that it complied with its 208 duty, which relates to placing somebody in.
Well, in my submission, this case and the others go wider than that, and they're looking at the more general duty is if you don't place in borough, have you complied with your duty, which I accept my Lord's point isn't contained in subsection 1, but appears to have been judicially interpreted as part of section 208, which is nevertheless to place as close as possible if you don't place in borough. And so what these cases are looking at...
That's not a duty. Is that a duty under 208? Or is it a duty under your following, the guidance from the boards? It's difficult to see how it can be a breach of 208 because 208 just says fast track control place within borough.
Well, I'm not sure that much matters, but if we go back to Nazelamesu, what the Supreme Court seemed to suggest is that it is deriving from 208. So if one looks at the ratio in Nazelamesu, which is paragraphs 36 and 37, on page 364 of the authorities bundle. At paragraph 36, the court's looking at whether the placement in Bletchley is sufficient to comply with the duty under the Act, and this seems to be the 208 duty. And what's said at letters D to E is that it's not, because Westminster hadn't explained whether they'd look for accommodation in area or nearer to their area than Bletchley and what was available. And then at paragraph 37, it says it follows that the authority cannot show that their offer of the property in Bletchley was sufficient to discharge their legal obligations under the 96 Act.
Perhaps I'm just being a little bit too picky about this, I'm not sure though. What Baroness Hale has done is to roll together the duty under 208, which is all about in-borough placements, and the obligation under the guidance, which is the only place, as my Lord pointed out very early in his hearing, you get the obligation to offer as close as possible. That's the only place those words come from. They come from the guidance.
Yes.
They don't come from section 208 itself.
Correct.
Right. So what Aaron Sale has done, both in this and I think in paragraph 19, is to deal, as it were, she rolls the two together. Although strictly speaking, I think the point we put to Mr. Pratchett earlier, that this, the word this in paragraph 19 probably refers to the guidance, not to section 208.
At the end of the day, it probably doesn't much matter whether we're strictly looking at 208, which I accept the point that on the strict reading of subsection 1, it's only focused on in area. The subsequent cases seem to refer to 208, and I've done it in my submissions in a more kind of generalistic way of this is your obligation to search for accommodation. And how my lords want to phrase that, whether it's a breach of section 208 or the guidance or some kind of combination of the secondary legislation, the suitability order, plus the guidance, plus 208, I'm not sure it much matters. The question is, what's the...
Judge Below seems to have found this was a breach of what was done was a breach of 208. I'm struggling to understand why.
Well, yeah, but it seems that he was using that in a more general sense, which is done in a lot of the cases, which is not really 208 subsection 1 on its pure wording, in what my lord referred to as its sort of vanilla sense, but 208 in a more general sense of how it's been interpreted by the court subsequently, which is an obligation. If you can't find in borough, you've got to find as close to borough as possible.
The guidance, if we're actually just looking at the guidance,
Yeah.
the guidance is couched, it's only guidance, number one, but it's also couched in much more less precise terms.
Generally and where possible.
Yeah, and the guidance...
Really, it's not mean in every single case.
Well, no, I mean, the obligation is as far as reasonably practicable. The guidance, if we're looking at it on page 174, paragraph 17.50, also doesn't refer to where the applicant was previously living, but take into account distance of that accommodation from the district of the authority.
174, sorry.
Yes, that's where my learned friend...
Two slightly differing things, haven't you? 1750 is rehashing Article 2 of the 2010 order, which talks about the distance between the accommodation and the district.
Yes.
1751 is now talking about accommodation as close as possible to where an applicant was previously living. And the two may not be the same.
Sorry, where's my lord looking?
I'm looking at paragraph 1750. I'm looking at page 174 of our bundle.
Yes.
Paragraph 1750.
Yes.
The housing authority is required to take into account the distance of that accommodation from the district.
Yes, exactly.
How far is it from the borough boundary of Enfield?
Yes.
And then 1751, housing authorities should try to secure accommodation as close as possible to where an applicant was previously living.
Yes.
Well, if you're living in, say, the westernmost part of a borough,
Yes.
and the local authority finds you accommodation just outside the eastern boundary, the two may not be the same.
Yes. Exactly. And I gave the example earlier. Imagine the applicant's not in borough at that time, but already way outside borough in Stoke-on-Trent. Then if you're going to place the applicants close to where they're previously living, you'd put them near Stoke-on-Trent, which doesn't make any sense. So that's why I said earlier, when my lord asked me about, is it close to where they were previously living or close to borough, there's some ambiguity about it. Some of the cases say, we'll see in a moment when we look at emoji, previously living, but the guidance contains both previously living and borough, and 208 subsection 1 is obviously just concerned with borough, not where the applicant's living. But in a sense, and I'll come back to the point I made at the start, it may not matter for the purposes of this case, because in this case the appellants did nothing, they didn't search at all. And the question really in this case is, can you do nothing and still comply with 208?
Yeah.
Can we?
Well, if that is the simple question, I'm not sure why we're even bothering to look at this, because 208 is all to do within borough, and if the person has said, I don't want to be in borough, why do you have a statutory duty to search?
Not only that, but it's dangerous for her to be in borough.
Yes.
I mean, if we're just looking at 208,
Yeah.
to pick your last point up, somebody says, I do not want to be in borough, it's
Mm.
dangerous for me. Why is there a statutory duty to search it in borough?
What we rely on is the way in which that section or the guidance or the SI has been applied by the court subsequently, which is that if they're not in borough for some reason, either because the authority thinks they shouldn't be there because they haven't got sufficient priority, or they say they don't want to be in borough, what duty arises then? And I hope to show by reference to these cases, it's a duty to search for accommodation as close as possible to borough, or possibly to where they were previously living, if they were previously living in borough. Because if they weren't previously living in borough, it's pointless to search for where they were previously living.
So, this is what I've thought. Suppose somebody lives very close to the border,
Mm.
and they are unintentionally homeless because of domestic abuse.
Yep.
And they say, I absolutely do not want to be in borough because of domestic abuse.
Yep.
And
In the borough where they've applied to, not the one where they're living. Are they close to the borough but in
Sorry.
borough? Right,
they are living in a borough,
right, fine.
very close to the border, and they are made unintentionally homeless due to domestic abuse. So
Yes.
they go to the borough,
Yep.
and they say, please can you find me accommodation? You have duty to me. I says yes. They say, I do not want to be placed in borough because of the risk of domestic abuse.
Yep.
Are you saying that the local authority has a duty to search just over the border and to find them somewhere as close as possible to the border and where they were previously living? That's the last thing they want, because it puts them straight back into, as my lord said earlier, the danger zone.
Yeah.
That cannot be the duty.
Well, like I said, but that's why there's the proviso as far as reasonably practicable, and it must be suitable accommodation, that's section 206, and obviously putting them in somewhere which is a danger zone.
Well, no, the reasonably practicable comes from 208, which is in borough. We're not in that.
No, but what I hope to demonstrate by reference to these cases is that that duty's been extended by these cases, so that if it's not an in-borough placement case, you have to place as close as possible, so far as reasonably practicable.
So what 1751 is in fact, you say ultra vires or contrary to section 208, because that's not what 1751 says. This extension of 208 your extension of 208 would invalidate the wording of section of paragraph 1751.
Well, I think it has to be read in context with the other provisions of the code, 1750, which say, well, if the applicant says they don't want to be there for whatever reason, you don't put them there. I mean, it may be in a situation where the applicant says, oh, I don't want to be in borough, that you've got a situation where the applicant's waiving their right to rely on the statutory duty. But the statutory duty still exists, but it's not a you must place them in borough. It's as so far as reasonably practical, and it has to be suitable accommodation. Should we just look at the relevant order, because I don't think we've done that yet. It's page 149. It's Article 2 of the suitability order. This doesn't impose any obligation to look in borough as close as possible, but it does require that the authority takes into account the distance, this is 2A, of the accommodation from the district of the authority. So it doesn't look at where they were previously living, but it is concerned with distance.
Well, I mean, the reviewing officer in this case did take into account the distance, didn't she?
Yes.
She said, not only have we put you in a neighbouring borough, we've put you in a part of it which borders Enfield.
Yeah, should we have a look at that? It's paragraph, it really starts at paragraph 41 in the review decision letter. So that's in the core bundle, page 97.
Yeah. end of paragraph 41. We
Yeah.
attempted to alleviate your distress and the possibility of isolation from your support network by accommodating you in a neighbouring borough, and in particular,
Yeah.
an area which borders Enfield.
Yeah.
So the underlying purpose of the guidance,
Yeah.
i.e. don't disrupt support networks, and that's exactly what the guidance says, is being fulfilled. That's what the reviewing officer was trying to do. She was saying, not to interrupt your support networks.
Yes.
Not only are we placing you in a neighbouring borough,
Yeah.
in particular, put you in an area which borders Enfield. So she's complied with Article 2, has she not?
Yes.
So we've got compliance with Section 208 because it's not practicable to house this lady in Enfield because it's dangerous.
Yeah.
We've got compliance with Article 2 because the reviewing officer has taken into account the distance between the accommodation offered at Enfield.
Yeah.
So that leaves us only with the guidance.
Yeah. Well, it leaves us with the duty as set out by these decisions which I'm going through. And the ratio of these decisions is, in my submission, twofold. It's firstly, there's a positive obligation on the authority to show compliance. And secondly, that must be supported by some kind of evidence. So it is insufficient, and the judge found this below, and it's not challenged, it's insufficient to say, we've put you as close as possible. The court requires something more. The court requires a demonstration through evidence of compliance with the positive obligation. So we were just finishing Abdicadir, and the last penultimate paragraph of Abdicadir, which is paragraph 59, page 523, is a statement as to the sort of evidence which an authority might wish to supply in order to show compliance. And in that case, my lord says, well, if you produce a statement showing or saying that you complied with the policy and explaining how that would be done, then that would be sufficient. So that's Abdicadir. If we then move on to the Zaman case, and if we start in Zaman at paragraph 37, which is on page 559, this was another out of area placement case, and the challenge was evidential, i.e. you haven't shown that you've complied with the duty, and we can see that at paragraph 37. The submission was that it was incumbent upon Waltham Forest to secure accommodation as close as possible to where Miss Simone was living, and the evidence does not show it to have done so. Now, the points of principle are set out at paragraph 47 because in this case, the authority sought to argue that really it didn't have to place as close as possible to borough. It could effectively place anywhere, and they relied on the code of guidance, which is there set out on the previous page 562, to say that effectively if they complied with their policy, that's good enough. And that argument's rejected by Lord Justice New at paragraph 47. He says at D, I do not think, however, that the change serves to excuse local housing authorities from seeking to provide accommodation as near as possible to their districts. So he formulates it as a duty to provide as near as possible to the districts, and he explains in the Roman sub-paragraphs why, and he relies on the suitability order, which we just looked at. Then he relies on the code. Then at Roman 3, he relies on what Baroness Hale says at Nzelamesu. And then at Roman 4, he says it's inherently improbable the Secretary of State intended the modifications to the sentence of 1750 to relieve a local housing authority of any obligation to try to provide accommodation as close as possible to its district. Yeah. So effectively, he's setting out the duty as one to provide accommodation as close as possible to the
So
district.
it comes from the code.
Yes, I mean, he relies on, as we've seen, the suitability order, the code, and the Zalamesu, and he stirs them all together in order to produce this duty to provide accommodation as close as possible.
Well, I'm not sure he does. In Roman 3, it says, like Baroness Hale said in his Zalamesu, paragraph 19, if it is not reasonably practical to accommodate in borough, they must generally and where possible try to place the household as close as possible to their previous agreement. She was reflecting the first sentence of paragraph 49 of the supplementary guidance.
So she wasn't laying down an interpretation of 208, she was simply reciting the guide.
Very well. Very well.
And 47 begins by saying that the authority must seek to provide accommodation as near as possible to their districts,
Yes.
not to the previous address of the applicant.
Yes, and I take also in 47 he starts by talking about the code of guidance. No, I take my learned friends by my lord's point. It doesn't, as I say, I'm not sure it necessarily much matters where the duty comes from, but the duty is.
Well, I'm not sure about that. If a duty comes from statute, that's one thing. If the duty comes from guidance to which the authority must, quote, have regard, unquote,
Yes.
it is not mandatory to apply the guidance. And that's well established. That's, I mean, in housing, homelessness context, that's Katoon and Newham.
And in terms, guidance is less rigorous in its expression than the statute. I mean, the statute says, as far as reasonably practicable, and Baroness Hale pointed out, it's quite a strong requirement.
Yes.
Whereas the guidance is generally.
I take that point, but what the cases seem to show is that's the duty, and that's the duty that the authority has a positive obligation to show compliance with, and an evidential burden to back up the positive obligation. Page 564, the judgment moves to Roman 5, which looks at what my lord had to say in Abdicadir. And then if one looks then at paragraph, well, then there's a heading, present case, and the judgment looks at two cases, I think both my lord's cases, Alibikiate at paragraph 50, and then Abdicadir at paragraph 51. And making the point of paragraph 51 that in the case of Abdicadir, Ealing didn't have sufficient evidence, and concluding at paragraphs 52 to 53 that Miss Zaman was successful in her appeal because Waltham Forest didn't have sufficient evidence to show that they complied with the duty.
Well, is that right? This is what Lord Justice Newey says, is there's nothing wrong with the accommodation acquisitions policy,
Yep.
but there is a dearth of evidence to show that it was followed. And common sense rather suggests that it was not. So in other words, Waltham Forest had not followed their own policy. That's the decision in the case.
Yeah, because of a dearth of evidence. So he's saying it's an Abdicadir case because it's another case where there's insufficient evidence to show compliance.
Yeah.
Paragraph 53 makes the point that although the policy might have been lawful, it's not apparent it was duly implemented, or that the address in that case, Longshore Street, was the closest to borough that the council could secure. So in my submission, this, rather like Abdicadir, reflects the fact that there's a positive obligation and you need evidence to show that you've complied with the positive obligation, and the positive obligation is a duty to provide accommodation as close to borough as possible. And that then brings me to the final case in the trio that I want to look at, which is the Modji case. In that case, Ealing had, by then, having read the judgment in Abdicadir, worked out that they needed some witness evidence to show that they had complied with the duty, and they produced that for the purposes of the Court of Appeal hearing, and at page 606 is paragraph 130. the Court of Appeal admit that evidence, and at paragraph 130 say that it was sufficient to show that there had been compliance.
Just sufficient.
Just.
That's what I thought.
Yes. And then at page 608, there's an attempt to try and encapsulate the general duty. So 142 makes the point that the section, and this is the point my lords have already made to me, the section doesn't say in terms that accommodation must be provided as near to an applicant's previous place of residence as possible, but it's settled law and not disputed that if it's not reasonably practical to accommodate an applicant in borough, the housing authority must generally and where possible try to place as close as possible to where they were previously living, and then refers back to Nizela Mesu and how that's known as the concentric circles approach.
Is Lord Justice Mayall's correct in saying that it's a judge-made expansion of section 208, or is it really just follow guidance?
We've had this discussion before, and I'm not really going to put any submissions forward on this point because
Well, speaking for myself, I think he's wrong to say this is judge-made expansion of section 208. Section 208 says what it says.
Yeah.
It's the guidance to which the authority must have regard, but it's not bound to follow, which talks about finding accommodation as close as possible.
very well. He then goes on, having identified what the duty is, and again, he's using at 142 as close as possible to where the applicant was previously living, was where the household is previously living, and I've already made submissions on that. But if one goes over to paragraph 146,
146, yeah.
146 on page 609.
Yeah.
He says, even allowing for a degree of flexibility, a local housing authority has a positive obligation to show that in offering an out-of-borough placement it's complied with its duty under 208. I understand what my lord's got to say about that. And he refers to Nizela Mesu and he refers to my lord's decision in Abdicadir. So he's again identifying it's a positive duty. And then he discusses at 147 through to 149 the sort of evidence that an authority ought to produce in order to show that it's discharged the duty.
Just stay with 146 for a moment.
Yes.
What Lord Justice Mayall's is saying is that the local authority must show that it's complied with its duty under section 208(1).
Yes.
It is common ground in this case. It was dangerous to place this lady in Enfield.
Yes.
Why is that not in itself sufficient demonstration of the local authority's compliance with its duty under section 208(1), i.e. a duty, where practicable, to house her in borough? What more is the local authority supposed to do?
Yeah. No, I agree with that proposition. But this was an outer borough, and so we're concerned with did they comply with the wider duty, however it derives, of placing as close to borough as possible.
Yeah.
And did they produce evidence to show, to back up their assertion that it was as close as possible? Although they don't even really assert that it was as close as possible because they can't do that because they haven't got any evidence, because they frankly admit they didn't make a search. So they can't show that it was as close as possible. All they can do is come to court and say it was close, but they can't. They produce no evidence because their case is, well, we don't have to because this duty doesn't apply to us. And when I say this duty, I don't mean 208(1. I mean the wider duty to place as close to borough as possible.
Yes.
And then at 149, it said, in considering whether the council has discharged that burden, so this is the evidential burden, the balance needs to be struck between, on the one hand, requiring local authorities to evidence and explain their decision, and on the other hand, what's been described as an overly technical or nitpicking approach. So if the appellants have produced some evidence, then given the circumstances of the case, depending on the quality of that evidence, it may be that the respondent couldn't do anything about it. But this is a case where they brazenly come to court and said, we haven't done any searches, we haven't got any evidence, because we didn't do any searches, we can't produce any evidence, but nevertheless we've complied. And in my submission, they can't do that because they can't comply with the positive obligation, because they can't evidence that they've complied with the positive obligation, because they haven't got any evidence. So the judge below is entirely correct to say, having accepted that you didn't do any searches at all, you can't come to this court and say that you've complied with the duty. And again, when I say duty, I mean the wider duty to place as close as possible to borough. So although on the face of it, the accommodation is close to their borough, they can't show that it was as close as possible. They can't show that nothing was available closer, or that there was nothing more suitable.
Do you say that the placement policy was unlawful in some sense?
Should we turn to the placement policy?
Yeah. It's not one of your grounds of appeal to the county court.
Well, no, I didn't challenge the policy, I challenged the application of the policy,
Yes.
and that was ground 2, and the judge found me
The
on
policy requires that the accommodation be close, not as close as possible.
that. Yes.
And on the face of it, as Mr. Paget says, that is an evaluative judgment for the reviewing officer. And if the reviewing officer thinks that property is close to Enfield, then unless that evaluative judgment can itself be challenged on judicial review principles, that's a question of fact for the reviewing officer, I would have thought.
Yes, I mean, I'm not sure Mr. Paget's actually directly challenged the finding on the policy. It may be that the judge below effectively said because the respondent has succeeded on ground 1, they also succeed on ground 2. But I take my lord's point that the policy doesn't reflect the same wording. It's core bundle page 112. But that may mean that the policy is unlawful because the policy must reflect the duty, and the duty is a duty to place as far as reasonably possible, not just close.
Of taking into account affordability and other factors.
Yes.
And the other factors might well be the factors which are referred to in 4.4, which include the ongoing threat to safety of the household.
Yes.
And I mean, that calls into question a point which my Lord Justice Snowden raised earlier, that would it be the case that if MB had lived one street away from the border of Enfield, and the local authority had been able to demonstrate that it had searched for a property closer to the border in Enfield and had found a property one street the other side of the border, that it would have satisfied its duty, as you now say it owed, and that would have been an end to the matter.
So is the question my lord's positing is if there'd been a property closer but in a dangerous area because it's close to MB?
It's out of borough,
Yeah.
but it's in fact only 2 streets away, with a border between the 2 boroughs, between the 2 streets.
So it's closer but it's in a dangerous area because it's close to MB? Yeah.
But they would have satisfied their duty, as you now postulate.
Well, if they'd done a search and if that was the only closer property and the evidence that it was the only closer property, then yeah, they would be entitled to say that obviously we couldn't put you there because that was more dangerous, so it wouldn't be suitable and it wouldn't be reasonably practical to put you there. But that's not this case because they didn't do a search and they're frank about that and haven't produced any evidence. Before leaving ground 1, can I just look finally at the Act? We've already looked at 208, but can we just turn up 206 because it's come up in argument. It's on page 110 of the authorities. Is there anything else we want to say on ground 1?
206, did you say?
Yes, 206, subsection 1, page
Yeah.
110 of the authorities. So this is the duty that any accommodation in discharge of functions under Part 7 must be suitable.
Yeah.
So, yeah. So that's where we get in the suitability qualification to the provision of accommodation. So if it's close to MB, we can disregard it because it's obviously not suitable to place there next to MB, but one can still comply with the duty. So, my lords, that's ground one. Can I turn to ground two?
Yeah.
So again, I just want to look at the scope of ground two. So if we go back to the core bundle to the amended grounds, and here we're looking at core bundle page 14. And it's paragraph 5, the second and third sentences. So the judge concluded that the County Court in the Section 204 appeal had jurisdiction to consider breach of 208. This was wrong because 204 appeals are limited to challenging a local authority review decision. So this ground is purely a jurisdictional challenge. My learned friend didn't really seek to resile from that. And if one turns over to page 15, one can see at paragraph 6 and 7 that what's developed in the amended grounds is a jurisdiction only challenge. So what he says is the judge below shouldn't have looked at this point at all. He didn't have jurisdiction to do so. It's a pure judicial review. It's a judicial review only. And that's the end of his argument. He doesn't then go on to say, well, if I'm wrong about that, then this is a case where it wouldn't have made any difference. And so the judge was wrong to...
Well, now the point's been drawn to your attention, I think you've really got to deal with it. How does a failure 14 days after the accommodation has become available turn a lawful decision on suitability into an unlawful one without the statute actually saying so?
So we don't say that it necessarily does. I'm going to deal with all the relevant cases, but we're not saying it's a binary black and white. If you don't give this notice, that's an unlawful review decision.
Well, that's what the judge seems to have decided. He
No,
decided, well, here's the duty, you haven't complied with it, that's that.
Well, let's have a look at the judgment, and then I hope to answer my lord's question in developing my submissions. So we're looking at ground 3, which is paragraph 50 onwards. And the relevant facts are at paragraph 54, which is on page 61. And they're really, as my lord says at the start of the hearing, they're required to give a notice. They didn't give the notice, so they're in breach. Then he sets out the submissions, and bottom of page 62, so paragraph 60, he finds that the court does have jurisdiction to consider the point. And then he deals with the issue of whether it makes a difference from paragraph 73 to 77. He relies on the fact that the notice had only been produced on the day of the hearings. That's top of page 66. There's no evidence from the appellants as to whether or not the notice had been responded to, and indeed there's still no evidence as to whether or not the notice had been responded to. He criticises them for not providing the disclosure earlier, and then he adopts my lord's approach in abdicadia at paragraph 75 and 76 by saying, well, I can't say that inevitably it would have been the same decision. And he also then says, well, even if it's a highly likely test, I find on a highly likely basis, highly likely the decision wouldn't necessarily have been the same. And so at paragraph 77, he allows the ground. So he's not saying the sort of binary absolutist position of no notice, invalid review. He's saying on the facts of this case, I just can't be sure that it wouldn't have made a difference. And we say that is the correct position.
Is that right? I mean, the submission that you made, which he records at 71, there was a mandatory requirement. There was a breach because Enfield didn't tell Haringey. And that was the basis of the breach, and you say, well, you can't say that it would have been, the result would have been the same, even if they had notified, and therefore that's your ground of appeal. And that was the ground of appeal as recorded in ground 3 of your appeal to the county court, where you say the respondents breached 208, 2 and 4, they didn't notify Haringey.
Sorry, where's my lord reading from now?
On page 87 of the bundle,
Oh,
so your ground 3 of your appeal to
Yep.
the county court. You say this is a mandatory requirement of primary legislation,
Yep.
clear statutory duty. Then you refer to abdicadia. So all you're saying there is that there was a breach of the statutory obligation.
Mm.
And that's what the judge decides, because he says, does he not, at paragraph 77, that you prove ground 3. Ground 3 says, here you have a mandatory obligation, you haven't complied with it, end of story. That's the way the case is put below, and that's what the judge accepted.
Well, I accept the first part of that. I'm not sure I necessarily agree with the second part. That was the case below, but the judge from 73 to 77 then sets out why he allows on ground 3. And he doesn't simply say, well, no notice or notice served late, therefore success on ground 3. He goes on to explain why, which is that he's very concerned that the notice has been served late and we don't know whether there was a response. And in those circumstances, given that the review didn't consider the non-service of the notice at all, he couldn't be sure that the same decision would necessarily be reached.
I'm struggling to understand how the outcome, using his words, or whether it's result or outcome, so far as your client's concerned, what difference does it make?
Well,
I read the paragraphs and I just couldn't understand what is he bothered about as far as your client is concerned, for her purposes.
well,
How is the outcome or the result any different?
can I say two things? Firstly, it doesn't matter for the purposes of this appeal, because as I hope I've just shown, my learned friend's ground is he had no jurisdiction to deal with this. And if my learned friend's wrong about that, and the judge below did have jurisdiction to deal with it, then that's the end of his appeal grounds, because he
Well,
doesn't go on and...
Yes and no. I mean, if a failure to notify post-decision does not affect the lawfulness of the decision, then he's right on the jurisdictional grounds, isn't he?
Well, I'm going to deal with the jurisdictional ground. I say he's...
You have to say, do you not, that a failure to do something within the 14 days after the decision retrospectively invalidates the decision such that it becomes unlawful at the end of the 14 days.
Well, my submission is I don't have to go that far. So, assuming it was a live issue in this appeal, which we deny it is because we say it's a pure jurisdictional point, but if we go on to look at does it make any difference, which is the point that the judge decided below against the appellants and they haven't appealed it, but we say yes, that it could make a difference. I'm not saying it necessarily does, but it could make a difference that they haven't served the notice. And I think what the judge was concerned about here is, well, did Haringey reply? Did they say, no, don't put her there because, I don't know, the block's listed for demolition, it suffers from appalling disrepair, it's extremely dangerous for her to go there. They could have had all host of reasons why, and he's very concerned that there may have been some practical result that might have come to the fore had they given the notice, or at least had they come to court and given some evidence as whether or not there'd been a reply. So when looking at this point, I'm going to look at 5 cases. I'm going to go back to James, look again.
How would that, even if that were all happened, i.e. decision is made by Enfield to place the applicant into Haringey, she is placed. No notice is given. If having placed her in a perfectly appropriate way, the response from Haringey would have been, oh my goodness me, you failed to take into account some aspect.
Yeah.
of this property, which we know and you didn't.
Yeah.
Why does that invalidate the decision that had been made? It might be grounds for it to be remade, but it doesn't affect the lawfulness of the decision which was made on the evidence and material.
So what decision are we?
I mean, that's the problem. The decision that we're talking about is a decision in a case.
Yeah.
All right. In a case, local authority places somebody into a neighbouring borough.
Yep.
Into a property which they go through all the stuff and they say, okay, this is entirely suitable. It's the closest we can get to our borough. This is it.
Yep.
They then fail to serve a notice. Why does that affect the lawfulness and the appropriateness of the decision, namely the decision to place, which is all that the applicant can really complain about?
No, well, we're not complaining about that. What we're complaining about is the review decision, which was a decision as to the suitability of the accommodation. And it could be relevant to the suitability of the accommodation. Because if Haringey came back and said it's unsuitable for whatever reason, it's subject to demolition, it's falling apart, the landlord's a road landlord, she's not safe there, those are factors which are relevant to suitability and therefore should have been considered in the review decision. And that's why it's important to do it. We don't challenge, the only thing we challenge on a homelessness appeal is the review decision. We don't challenge the decision to place, the decision
It's a very odd form of judicial review principle to say that although the reviewing officer was entirely incorrect in deciding on the information that they had, that the property was suitable, because of further information which subsequently comes to light, that decision is now unsuitable? That decision is now unlawful?
Well,
A decision is either lawful or unlawful when it's made.
I say it's classic public law principles of, well, did you make proper inquiries? Did you take account of all relevant considerations? And if you haven't served the notice, which might have given rise to the obtaining of certain relevant information, then you haven't done your job properly.
But that doesn't work, Mr. Van Heegen, because you don't have to give the notice until after the accommodation has been made available to the applicant. You've already decided by that stage, this is the accommodation which we're making available.
Yes.
So it's not a question of making inquiries before the decision. This is something that happens after the decision.
Yeah, no, I'm referring to the review decision because that's the thing which we're challenging. We'll go to the case in a moment, but as I think my Lord said in the previous case, this is a reconsideration. So we're looking at the facts and the law afresh at the time of the review. And so therefore you have to take into account of all relevant matters. We're not fixed in time at the time of the offer because it's an acceptance case. And in an acceptance case, you look at the facts and the law at the time of the review.
So just let me get this straight then. So the duty to notify is a duty which arises when the accommodation is made available.
Yes, my Lord says in advocacy it's when the offer's made.
Yeah. There is that the applicant is entitled both to accept the offer and request a review of the suitability of the accommodation. And plainly that takes a bit of time because you've got to go through all the processes of minded to find letters and all the rest of it.
Yep.
So you say then that in the intervening period between the original decision and the review decision, the reviewing authority remains under a duty to make reasonable inquiries.
Yeah.
And that duty includes the duty to notify the host authority of the out of borough placement, so that any response from the host authority can be fed into the review decision.
It may be relevant. If they reply and if they say something that's relevant, then it should be taken into account in the review decision.
And if the placing authority notifies the host authority 21 days after the decision instead of 14, does that make any difference?
Other than it's a breach, the real question is, do they respond and what do they respond with?
Yeah.
Which is why the judge below was so anxious to know, did they did they respond? And it is surprising that we come to court today and we still don't have that evidence, because if they had evidence of no, they didn't respond, then the argument's going nowhere. But as the judge below pointed out, we can't be sure that A, they didn't respond, and B, that they wouldn't produce something relevant, and therefore inevitably the decision would be the same, or it's highly likely it would be the same.
Your argument would certainly gain traction if there was any duty on the host authority to respond to the notification, which there isn't, as we've discussed in previous cases.
In Abdi Kadir. Can I respond to that?
Yeah.
So if one goes to the Act, we've looked at 208, so I don't want to go back to it. My Lord's right that there's nothing in 208 which obliges a response. But as my learned friend pointed out, there are a number of statutory duties which sit on the notified authority. So they can't just sit on their hands when they know. If we go to, let's start at 208 and then go, I'd like to go to 2138. If we start at 208, which is page 113 of the authorities, subsection 3 sets out what the notice has got to contain.
Yeah.
And I just want to draw the court's attention to B. So the number and descriptions of other persons who normally reside with him as a member of his family. So there is some detail given here, and in my submission what that's aimed at is children. Are there any children? You've got to describe them. So at the least you've got to say whether or not they're children, and you may also...
Well, you don't have to say whether they're children, actually.
No.
The word children isn't in fact used.
No, I agree.
Interestingly.
But description. So you're not going to say they're tall with brown hair.
No. But there is a point to be made under Section 11 of the Children Act 2004 or Section 17 of the Children Act 1989. There are duties which apply in relation to children.
Exactly.
And if this was intended to attract the duties which apply under the 2004 and 1989 Act in relation to children, one might have expected to see the word children there.
Yeah, I mean, I take that point, but there's got to be a description, and I think the age of the person is likely to be part of that description. You're likely to put down the dates of birth of the people. And if you do that, then my friend identified a number of statutory duties. So then the Children Act would come into play, because if you suspect there's a child in need, then you have to do something about it. So in answer to my Lord's point of, well, you don't have to respond to the notice, that's true if you look at Section 208, but not if you look in a more general sense. Because if you're a unitary authority and you've got Children Act duties, you do have to respond if you think there's a child in need. If the adult is described as in need of care and attention, you have Care Act duties. So you do have to respond in the sense you might then assume Care Act duties. And if you're an educational authority, you have to make sure the child's got educational facilities, school place. So you do have to do stuff. So although in Section 208 it's silent about response, one has to look at it as part of a web of sort of wider community care provisions, which would place an obligation on a notified authority to do something. And we see a bit of that at 213 capital A, which is just further along at 100.
You're moving on to a rather different point, Mr. Van Heegen.
Yes.
Your original point, as I understood it, was that notifying the host authority might result in the production of material which is relevant to the suitability of the accommodation in time for that material to be available on any review of suitability.
Yes.
Now, that's got nothing to do with other duties which the host authority may have. There is no requirement to respond under Section 208 to this notification.
I agree.
So it seems unlikely, doesn't it, that the purpose of the notification was to prod the host authority into providing material useful to a review.
I don't necessarily accept that. I think it could prompt the host authority, the notified authority, into producing material that's relevant to the review. And that could either be a response of, no, don't put them there because we're just about to build a motorway down that road, or it could be that they then carry out a Children Act assessment, or they come back and they say, oh, these are children, but you've produced 4 children and they all got to go to school now and we just don't have places for them. And so it could all feed into the issue of suitability. I was going to look at 213A, which is on page 126.
We're just going to pause for a couple of minutes. Don't leave the courtroom, we'll be back shortly.
Is Lewison really going to turn around and say, well, the duty derives from the guidance, you've just got to have regard to it, so what the heck? I mean, that's the worry, because if it doesn't derive from the statutes, I mean, they're right, it is important where it comes from, because if it doesn't come from the statute, it only comes from the guidance, you've only got to have regard to it, you don't know if you have to comply. Where'd you get that from? You've got to comply with the code of guidance unless you've got good reason to depart from it. Is that the principle? Well, let's try and find that, because that is useful, isn't it? Maybe bring it back this afternoon, because we're not going to finish by 1. It does vaguely ring a bell, that principle. Actually, grounds who's not going as badly as I thought it would. Maybe because we've got Snowden and we've got this guy now who knows about children and duties, who's obviously going, oh yeah, all about the children and duties. Maybe our point is simply that if the duty does come from the code, then they've got to explain why they're not complying with it. In fact, they don't even acknowledge that it comes from the code. It's quite an interesting game. So it needs to go back to the Supreme Court to decide. Because they're on the stripping in subsection 1, they're okay. Yeah, that's true. Yeah, well, steady on though, easy to look at. He's saying that's his wrong, but not that in. And it's really. Yeah, exactly. He's not going to be stupid enough to put that in the judgment, though, is he? He's going to say it comes from the guidance, therefore it's duty to have regard. Did Snowden just have too much of the pizza in Cobb's room? Looking really ill.
Rise.
Rise if able.
Yes, it's that.
So, well, also, we're just looking at sections in Part 7, which may be relevant to the 208 notice. And we're looking at section 213 capital A, which is on page 126 of the authorities.
Sorry, just a minute.
213 capital A on page 126 of the authorities. And this places an obligation on the local housing authority in certain cases involving children. I just flag it up because this may again be something which is triggered by the giving of the notice. The receiving authority might become aware that they're children and then may have to tip off their social services department. I also want to look at section 198.
Sorry, just a minute. This is about cooperation between a housing authority and a social services authority.
Correct.
This is not about cooperation between different authorities, different housing authorities for different districts.
No, agreed. So the way in which it would be relevant here is the notified authority gets notice that their children coming to their area, and therefore they have to tip off their children's services department.
Why?
Because they have reason to believe that an applicant with whom a person under the age of 18 normally resides may be homeless.
I'm sorry, I don't understand. I don't understand this. The section applies where an applicant may be ineligible for assistance. Well, that's not this case
That's not
because she
this
was eligible for assistance.
Yeah.
Or may be homeless. Well, that's not this case because she's just been placed in Haringey. So, where does this get you?
Because
You say she's still homeless because she's only been offered temporary accommodation.
yes, I mean that's why I drew my lord's attention to the homeless point. But I mean, I see my lord's point. If she says it's not suitable accommodation, so but if she's wrong about that, then of course she's not homeless.
Yeah.
The prima facie, it could be construed that she is homeless because of what she says about the accommodation. Therefore, the children are too, and therefore there ought to be a reference to the Children's Services Department of that local housing authority. Or if they're not a unitary authority, then to the county council.
Does this all presuppose that the host authority receiving the notice under 208 has either the inclination or the resources to do anything with it other than receive it?
Well, yes, but they've got community care duties set out in primary legislation, but yes, they could, as was suggested earlier, just scrumple it up and put it in the bin. But if they do that, they're potentially in breach of a number of duties which we've identified under the Care Act, Children Act, Education Act.
Right, there's another section you wanted us to look at?
Yes, it was 198 subsection 4.
Sorry, would the information given in the notice, alert, that's required to be given in the notice under 283 actually be sufficient to alert the host authority of any of these matters?
With that comes back to the point we raised earlier, I raised earlier about what's meant by description. I mean, I rather hope that would at least cover the age or whether they were children. But I take my lord's point. It may be whether they've got brown hair or something, in which case it's not going to trigger. I want to draw the court's attention to section 198 subsection 4 on page 77. Just for we'll see in a moment in relation to abdicadia, but you can, so if she's placed in Haringey and she applies to Haringey subsequently for homelessness assistance, then for the 5 years after the placement, Haringey are entitled to send her back to Enfield. But after 5 years, Haringey have to take the application And so in Abdicadir, the local authority said, well, this could be one reason for the giving of the notice. So the notified authority is clear when the 5-year period starts to run from. And then just in relation to the Act, before we move to the cases, there are a large number of duties in Part 7 of the 96 Act. None of these duties specify a sanction for non-compliance. So Section 208 subsection 2 is not anomalous. It's just one of a number of duties. And as a matter of public law, the court's got to eventually decide, well, what is the consequence of a breach of this duty?
Yeah, well, and there seems to be a question that's arising more and more, no doubt, as a result of recent case law.
Yes. Yes.
Taught, are we not, to ask, well, what's the consequence?
Yes. Exactly. So there are 5 cases that are relevant on this. James, which I want to go back to very briefly. Abdicadir, which I need to go back to briefly because it's the only case that's considered 208 notices. There are 2 Norton cases, the old one and now the new one, and then the Barnett case. So taking them in that order, if we go back to James, which is in the authorities bundle, I think my lords have already got the point from paragraph 2, which is on page 438, end of paragraph 2. It's a priority needs decision in James. And the issue which is taken is that the review is not lawfully contracted out. So the issue taken has got nothing to do with the substantive decision. Contracting out does not impact on whether or not an applicant has a priority need. So the point's taken, rather like my friend's taken it today, about jurisdiction, and starting at paragraph 18 on page 442, the court look at the case of Nipper Begum, and at page 443, letter C, they quote a large section from Nipper Begum, which is dealing with, well, why was 204 introduced? What's the policy behind it? And the policy behind it is to relieve the administrative court, of the burden of dealing with all these homelessness cases by shifting them into the county court. If my learned friend's right, and we can only challenge the not giving of 208 notices by way of judicial review, then obviously all those things have to go back into the admin court, which rather undermines the whole policy behind 204 appeals in the first place. Turning to paragraph 22 on page 44.
That assumes that people will be bothered about challenging the giving of a 208 notice, or will even know that it's not being given. I mean,
yeah, I'm going to address that point at the end because my submission on that is going to be it renders it completely pointless. And this rather comes back to the point which was discussed earlier about where it's not even a duty owed to the applicant. So the applicant's not necessarily going to even know if it's been complied with, as opposed to housing needs assessments, which are considered in Norton and the new Barnett case, which is a duty owed to the applicant. So the applicant knows whether or not it's been complied with. But I'll come back to that point. Paragraph 22 refers to the Tachi case, which is about contracting out, and in which Mr. Justice Jay in the High Court held that there was jurisdiction. Paragraph 24, the court looks at Nazela Mesu, and that was the case where Baroness Hale talked about the ability to challenge the lawfulness of policies within the context of a homelessness appeal, though also she said they could do it by way of judicial review. And in my submission, that's possibly the answer to ground 2, which is that it's not a binary, do you do it by judicial review, do you do it in a homelessness appeal? It may be a case where you could do both. It may be like a challenge to a policy. But in any event, we say that the jurisdiction of Section 204 is wide enough to encompass a challenge to not giving a 208 notice. And then paragraph 28 sets out the submissions for the authority, and Mr. Bose's third submission at the bottom of 446 was that if the county court's jurisdiction extends to enabling applicants to challenge the exercise by authorities of Housing Act functions, it would potentially extend to other legislation.
Yeah.
But that argument's rejected. The court's perfectly happy for it to extend to other things rather than the pure matters which are relevant to priority need, and we can see that at paragraph 31. The court's already been taken to paragraph 31. But effectively, the points made, well, 204 includes anything you could argue on judicial review.
Yeah.
So it's a nonsensical argument to say, well, this should have been raised on judicial review, because if it could have been raised on judicial review, it can be raised in the context of a 204 appeal. So that is James, and then the next case is Abdikadir, which, as I say, is the only one on 208. And if we go, starting at paragraph.
How does James, I mean, this may not actually directly matter, but how does James chime with Fatou Lazadeh?
I'm going to deal with that when I move on to Fatou Lazadeh, which I'm calling the Barnett case. Because what I say is that neither Norton nor Fatou Lazadeh consider the jurisdiction under 204 or any of the relevant case law. And really, it's a bit of a throwaway comment in Fatou Lazadeh that, oh, well, you could do judicially reviewed. But even if you could have judicially reviewed, it doesn't mean you can't raise it on 204 appeal.
All right.
So if we could go to Abdikadir, page 516. There's a heading at the top just before paragraph 23, duty to notify. This is the only case which deals with 208 notices. There's no issue of jurisdiction raised.
No, it wasn't raised, as you quite rightly say.
Yeah, and the court obviously deals with it. So no problem with dealing with it in the context of a 204 appeal. At paragraphs 24 and 25, I set out some of the reasons why I thought the notice might have been of use, which my Lord rejects at paragraph 25. Paragraph 26, my learned friend in that case then says, going over the page top of 517, that it might be because the notified authority will want to know when the applicant's moved to their area, and that's not rejected by my Lord. Therefore, that may be one of the reasons for the giving of the notice. And then at paragraph 29, my Lord decides that because it was a refusal case, Miss Abdikadir refused the accommodation, and therefore the 1932 duty came to an end before the obligation to give the notice expired. There was no breach of 208 on the facts of that case.
Yeah.
And then my Lord deals at paragraph 32 with the point about if it's a refusal case, you look at the law and facts at the time of the refusal, but if it's an acceptance case, then you look at the law and facts at the time of the review. And then my Lord says at paragraph 34, had Miss Abdikadir accepted the offer and actually moved in, then the duty to notify under section 2082 might have had greater significance, but that's not this case. So in my submission, it cannot be said by my learned friend that the giving of the notice is entirely irrelevant and is always entirely irrelevant to the review decision on suitability. And I would adopt what my Lord says at paragraph 34, that it might have significance depending on the facts of the case. And obviously this was a case which we've already seen, which the judge below decided that it did have significance, and that has not been appealed. So that then brings me to the first of the Norton cases. And if I could take the court to page 537, paragraph 42. What's happening in Norton is a private rented sector offer is made and in discharge of the 1932 duty. And there are a number of things which have to be done in order to make a valid offer to get rid of your 193 duty. And so paragraph 42 begins. Section 193 imposes a series of what might seem to be rather technical requirements on a local housing authority. They are, however, the requirements which Parliament has imposed on local housing authorities in order to protect the statutory rights of people who are or may be homeless. And those rights are or may be affected by actions taken by the local housing authority under section 193. And if the local housing authority is to bring the duty imposed by 1932 to an end, those requirements must be complied with. And in my submission, section 208 should be considered within that category as requirements that must be complied with in relation to making an offer which has the consequences of ending the 1932 duty. So Norton then goes on to consider paragraphs 43 to 45 the various requirements which were raised in that case and not complied with. And because of the non-compliance, the appeal was allowed for each of those reasons of non-compliance. And then there's a section on relief on page 538. And at paragraph 43, Mr. Grundy argued that the challenges were technical and they didn't involve any assertion that property 2 was really unsuitable. So effectively making a similar point to my learned friend today is, why are you complaining about something which is not directly relevant to suitability? But that was rejected by the court, and the court did grant relief. Before leaving this, if I could just look at what Lord Justice Mayles had to say at paragraph 63 in his conclusion.
53.
63.
Hmm?
63, page
63.
63.
Yeah.
Housing law can be highly complex. More specifically, it demonstrates that local authorities who wish to discharge their housing duty by provision of an assured short-hold tenancy of private law must take care to ensure scrupulous compliance with the terms of 193. Obviously, the 208 notice is not in 193, it's in 208. But the point being made by this judgment is that there are a number of requirements. Yes, they look technical, they make it all very complicated, but they're there to protect applicants. They have to be complied with, or as Lord Justice Mayles says, scrupulously complied with. And then if I could just turn to the two cases which my Lord's drawn the party's attention to, Norton and the Barnett case. So as I said before, neither of these cases is to do with the jurisdiction of 204. They don't look at Nipper-Bagan, they don't look at James, they don't look at any of the relevant case law. In the Norton case, my Lord says at paragraph 31, so I'm looking at page 694 of the authorities.
Sorry, which paragraph?
31.
31. Yeah.
The Lord says, I do not doubt that an assessment of suitability based on an unlawful or otherwise legally flawed assessment under 189A is itself legally flawed. So this shows a link between an unlawful housing needs assessment and an unlawful suitability review. If you effectively adopt on review what is an unlawful housing needs assessment, then your decision on review is also likely to be unlawful for the same reason as the housing needs assessment. And that's why prior unlawful decisions can infect a later review decision.
But on your argument, you could wait until a review decision and attack the preceding assessment. You wouldn't have to go to the administrative court.
I'm not making submissions on challenging housing needs assessments. I'm just focusing on 208 notices, which I say.
I follow, but I'm just, you were discussing the ambit of a section 204 appeal.
Yeah.
And you would say, presumably, that in all these cases in the administrative court, the applicant could have waited until a decision on placement or a review decision, and in the course of a section 204 appeal could have said, well, the initial PHP that you prepared was itself flawed, and therefore your review decision is flawed. So it could all have been done in a 204 appeal.
Yes, if, as my lord suggested, paragraph 31, the review adopts the same
Yeah.
flaw.
Yeah.
So if the housing needs assessment says, well, you need a 1 bed, but actually they've got 6 children, and on review, the review says, well, we've offered you a 1 bed, it's perfectly suitable for you because look, in the assessment we said a 1 bed was enough.
And it's that is queried in Barnet.
Yes, I'm going to come to Barnet in a moment. I just keen to characterise the nature of these appeals. So they were rather binary appeals in the sense that what was being argued in Norton was no housing needs assessment, no valid review decision. And we certainly don't take that extreme absolutist binary position. We take the position really that my lord set out in Abd Qadir is that it may have significance. And so we don't say that the breach of 208 of itself invalidates the review. And at paragraphs 50 to 52, my lord in Norton exposes the illogicality of the appellant's argument in Norton, which was effectively, at the end of paragraph 50, in the absence of any assessment under section 189, that there are a number of consequences, which really don't make sense, which rather shows how the extreme position cannot be right, as my lord says in paragraph 52. But that's not our argument in this case. And then that then takes me to Fatalazadeh. So again, Fatalazadeh is not a case about 204 jurisdiction. None of the relevant cases are cited, no sign of Nipper Begum or James. And as we'll see in a moment, what was said about judicial review is rather a sort of throwaway comment, but still nevertheless a correct statement of the law that you can challenge housing needs assessment by way of judicial review. And I accept that you can do that, but that doesn't rule out that certain things which can be challenged by judicial review can also be challenged in the context of a homelessness appeal. And we've seen as examples contracting out, attacks on policies, and I say and not giving of a 208 notice might be something which is relevant to a suitability review as well. So in this case, if one looks at paragraph 31, we can see that again, the appellant was taking a very extreme position. And at paragraph 31, it said that the appellant's submissions are found on contention that Barnet carried out no section 189A assessment of the appellant's case, and on that basis it's contending it was at all material times unable to discharge its prevention duty under 1952. So the extreme position is taken of no housing needs assessment, no valid discharge of duty, and that's not our argument, and we don't adopt that extreme position. And one can see from paragraph 40 that in any event that position was fundamentally flawed. Paragraph 40, the appellant's case on ground 1 is fundamentally flawed because it's based on the assertion that Barnet didn't carry out an assessment of their housing needs. That assertion is unsustainable. And in fact, the court then goes on in the following paragraphs to identify that in fact Barnet did carry out a housing needs assessment. And so the argument, no housing needs assessment, no good discharge and prevention duty, was just a bad argument on the facts. Paragraph 44, the court identified that there was an assessment, but it was deficient because it didn't properly consider the distance of the property from the appellant's support network. And then at the end of paragraph 44, the court then rewrites the ground. And then this is where we get on to judicial review in paragraphs 45 and 46, where it said, I would readily accept there may be circumstances where a failure to carry out an appropriate assessment may be challenged by way of judicial review proceedings. And that's right. You can challenge a failure to carry out housing needs assessment by way of judicial review, because it's not something that comes within the scope of 202. But as I've said earlier, relying on what my lord says in Norton, that doesn't preclude you on a suitability review from going back and saying, well, this suitability review is flawed for the same reason that the housing needs assessment's flawed. You're not precluded from raising, in the context of a homelessness appeal, a point which you could have raised by way of judicial review. And in fact, in this case,
Yes, I think that Lord Justice Stuart Smith disagreed with me at 56.
yes, we'll get on to that. So just looking at 46, there's a criticism that there's no judicial review challenge, but it's not said that it couldn't have been raised. Same points couldn't have been raised on a homelessness appeal, and there's no consideration of that jurisdiction. Then at 47, 48, they consider the cases, one of which my Lord drew out.
What about what Lord Justice Stuart Smith says at the top of page 711? He says, time for challenging by JR is limited.
Yep.
No JR challenge was brought within time or at all, and it would have failed, right, etc., etc. In this case, the assessment was not challenged at the time, and having not been quashed, it remains valid. That would suggest that you can't. I know he doesn't say this in terms, but the thought underlying it must surely be that if you don't challenge it by JR, you can't raise it on the appeal from the review decision.
Well, he doesn't say that, and what he does say is a correct statement of the law, that if you don't challenge it, and if it's not quashed, then it's a valid assessment. Doesn't necessarily mean.
How do you square that with your being able to say on an appeal from the review decision that it wasn't a valid assessment because it didn't take into account one thing or another?
Really, for the reason my Lord says in Norton, that if it is flawed, it still stands as an assessment, but if you can show that there's an error in the review decision, which is a sort of similar error in the assessment.
That's where I think Lord Justice Stewart wouldn't agree.
No, I know. We'll come on to it.
Unless you actually quash it,
yeah,
that's it. It stays.
Yeah, but we're a long way removed from the situation we have in this case. Yeah. Does my Lord want to break there? Does my Lord want to break there, because it's very nearly 1 o'clock?
How long are you going to be?
I've got to finish this.
Attention, please. Attention, please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected.
That's a problem.
Please continue normal business.
So we will break now. We'll resume at 2. We're obviously going to finish this very comfortably this afternoon.
Yes.
Attention, please. Attention, please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More